Right. Good afternoon, everybody. It's January 25, 2024. It's been a really long hiatus since our last webinar, so I'm so happy to be here with all of you, and especially with Kent Weichmann and Kristin Arnett. Let me tell you a little bit about our people here today. Before we launch into our topic of child support and the impacts on parenting time and vice versa. So a lot of you already know Kent Weichmann. He is a former chair of the family law section, and he has his firm is Mediation and Arbitration Services. He used to work with the Washtenaw County Friend of Court. He's also worked with the Wayne County Friend of Court. And he's most importantly for the conversation today, he's been on the SCAO Friend of Court Bureau Michigan Child Support Formula Committee since 1984. Am I right? 1984.
Yeah,
okay.
I'm afraid so.
And in case he's going to tell us more about that process, but they just recently completed their work in 2023 for the updates that will go into effect in 2025. And then I also have Lansing attorney Kristin Arnett, and really excited to have her here. Kristin and I actually worked together at my first job in Michigan when I moved here from Texas in 2003. And she just last week finally opened her own law firm, even though I've been trying to get her to do it for a long, long time, Arnett Law and Mediation, and it's here in Lansing, Michigan. And she does mediation for both family law and probate cases, and also does a little bit of, I think, trust administration. She's currently the president for the Board for Dispute Resolution Center, which is also here in Lansing. So welcome to both of you, and thank you.
Thank you.
All right, so we're going to kick it off with first I wanted to see, because we have a lot, Kent's going to be talking for a bit today about the updates to the formula and then some history of how the child support formula has developed over the years. So before we jump into Kent, I wanted to give Kristin a chance to, if she had any introductory remarks she wanted to say about our topic today.
Thanks, Lisa, and I'm really happy to be here today. I will be taught after Kent does his wonderful presentation. I'll be talking about various tensions in mediation having to do with parenting time as they relate to reaching an agreement, specifically focusing on the overnight issue, how to get past that. So
great, thank you. Okay, so Kent, we're going to start by launching into, I think, just a brief summary of the changes that you just went through with the Child Support Formula Committee that, again, won't go into effect until 2025. Can you give us like the highlights of the most important things that we need to know about as we prepare for January 2025?
Yeah, so you've got a year before the new one takes effect. And you can actually get a copy of it already on one of the documents we share. I have the links at the bottom, or you can go through the State Court Administrator website, find the Front of the Court Bureau, find the Support Review Committee, and in the materials, they've got it hidden, the links there. So you could actually download it now if you want. And when you do it, if you do, on I think the third page, they have this document. Let me see if I can pull it up. The changes, oh, come on.
And while Kent's pulling up the document to show you, I will be circulating what we call takeaways sometime after the webinar. If all goes well, it will be tomorrow, but more likely early next week. And there will be the link to make it really easy for you to get access to those changes.
Let me see, there we go. So a lot of it is what we call clarifications. A lot of times we kind of hide changes by calling them clarifications, but most of these early ones are really clarifications. But I would like to call out a few things that aren't. This one, the count income when there is reduced or deferred income, particularly where a business does not distribute profits. That's actually a big thing, because what it really means is we redefined what happens when there are retained earnings in a business, especially a sole proprietorship. The way the manual used to be written, if you retained earnings, it wasn't considered part of your income. Well, there's still earnings, right? And if you just kept it in your business and didn't take it out, then it was considered not to be income. So you could earn a lot of money and never pay child support on it just by hiding it in your business. And this provision says, no, the court can still consider retained earnings regardless of your past practice on that. So that was actually a pretty important change. The other change that I'm not all that excited about, this deals with imputation of income, this 201G3. And it always used to be that if you imputed income, you also had to consider what the kind of costs of earning that income. So you're pretending someone's working when they're not. Here's what they would make, but you'd also consider the costs. For instance, childcare was a big one, taxes that you'd have to pay if you earned. It's now discretionary. It used to be the court shall consider. It's changed to may. And that's huge. It means you could impute income to somebody where there's no possibility of them working unless they had childcare, and you wouldn't have to consider the childcare that they would have to pay. And the reason for this is not a good reason, but it didn't make sense in most cases to impute income to a non-working parent if you also had to consider childcare, because by the time you apportion the childcare between the parties, it made it worse. In other words, if you imputed income to someone thinking, oh, that'll reduce my child support, no, your child support would go up because of the imputed childcare. And so I think there were decision makers who were frustrated by that. They wanted to impute income, but they realized it wouldn't have the effect that they wanted. So now it's discretionary. Hopefully courts will still do it, but they don't have to anymore. A lot of other things. Back in 2021, there was a huge, and I don't know if you've noticed it in the current formula, but there's a whole lot on incarceration. There was a concern that many people who were incarcerated still had child support orders running. And it meant that when they got out of prison, they would have this enormous child support debt that could never be collected. And it also made it very hard for them to kind of get a fresh start in society when you're already saddled with a debt, which might be a violation of probation. And it was essentially just routing people into jail. So a lot of stuff in here is kind of cleaning up some areas where it wasn't cleaned up before. So this 301B changed apportionment of actual share. We always said you had to at least pay 10%. So for instance, if there were medical bills, you always had to pay at least 10% of them. If there were, you could never reduce it. If you had 0% of the income, you would still have to pay 10% medical bills, 10% of childcare, 10% of things like that. It's now, if you have 0% of the income, then you pay 0%. And that's there, and it's also down in 402B. You can set incapacitated parents' obligation percentage to 0. All of this saying that you're not going to charge people support of any type if they're in jail and have no ability to pay whatsoever. So that was a big area of emphasis. The other area that they worked on a lot was this 304A and B, where the ordinary medical expenses is part of medical expenses that are built into your child support. And the reason for that was, rather than having every medical bill submitted to the front of the court to be apportioned between the parties and send out the letters saying you owe this amount and all that, it was like, hey, look, the first, and I think it used to be something around $400 that you would say, we assume everyone's going to have at least that much. And so we'll just build that in. That's part of the support. You pay it every month and you're done with it. Well, a lot of people were concerned because they had the misfortune of having healthy children. So there weren't those expenses, and they felt like they were being overcharged for having to pay expenses that didn't actually happen. And so two things happened. They reduced that built-in amount to $200 per year. And again, that's a portion between the parties. So it means that the vast majority of people are going to hit that anyway. And the second thing is, it's much easier now to not have ordinary medical built in at all. That, for instance, if the parent paying support is actually the one who's always taking the children to the doctors, there's no point in building in an ordinary medical to be paid to the other party, right? Or if you've got something on your the way your health insurance works, so that there are in fact no uninsured medical costs, well, then you don't need to build it in. And so it's easier to get out of it for those instances. And hopefully that will eliminate some of the apparently there was a lot of aggravation by people around the built-in ordinary medical, even though it's not a huge amount. I mean, I think the most you could possibly have was something like $30 a month. But for some people, especially if there are a lot of children, that might be more. So that was an issue. So anyway, those are the changes. You've got a year to get ready for them, and I don't think they're huge anyway.
Well, I have two questions, one from me and one from the audience. I'll do the audience first. How does what you just talked about work with the reimbursement to the state for Medicaid? Is that too complicated?
That was a big issue.
Okay.
And as a matter of fact, we had the person from Office of Child Support dealing with it. And it is a sizable amount of reimbursement to the state. And the answer was, that's not as important as kind of getting it right. And so it will affect the reimbursement that the state and the feds get for Medicaid expenses. And that was recognized and deemed not to be as important as trying to get it right.
So, and my question has to do with if folks find out as they're representing their clients that they have a problem with something that the way that the formula is written is, for example, if they're having issues with the cost of employment change as they're starting to deal with that and finding out that it's like really becoming burdensome, is there a mechanism to like let the committee know, like for the next time? So you do, I think you do the review every 4 years?
It's
Yeah,
a quadrennial review now.
Right. Is there a way to let the committee know, like, hey, this is what we're having problems with?
Actually, yes. And I should have pointed that out. The same area where I mentioned, if you go to the court website and go to the state court administrator's office, go to where they say offices, and then that links to a number of offices, including the front of the court bureau. Within front of the court bureau, you then click down to the Michigan Child Support Formula Committee. And when you get down inside that link, there'll be something where you can submit issues that you're having with the child support formula. And they assemble those. That's actually where our review starts from. Oh, Paul Game is on. That's even better, because he's just provided you with the link. And so part of our review is to go over all of those comments and concerns, and to see which ones we can address, which ones we think are already addressed, and which ones we don't think should be addressed.
Great. Well, thank you, Kent. Now we're going to change gears and talk about the child support formula, and particularly to help us understand where we are. I think it's going to be helpful for Kent in particular to explain where we came from with respect to child support and parenting time. So I think we have a little history. I know you wrote up something I'm very happy to share with everybody. Thank you for writing that up. But you were trying to, when we were planning this, you were explaining to me how the child support, the parenting time would impact the child support and how it's changed a lot over the years.
Right.
Do you want to just start with what it was, what you called the quote ratio of the squares?
Yeah, well, why don't I start by just from the very beginning. I mean, we actually started meeting in 1983 to try and come up with, when the Front of the Court Act was passed back in 1982, one of the duties it imposed on the state court administrator's office was to develop a formula to be used for child support statewide. Because one of the complaints about Front of the Court was child support varied widely from county to county. So there was going to be a statewide formula. And when we were working on that formula, very early on, it became clear that you had to take into account how much the children were with each parent. So for instance, if you had true, absolute 50-50 possession, that was a lot, child support would be a lot different than if the children spent 100% of their time with one parent. And so from the very beginning, that was taken into account. I'm going to share a document. This is my best attempt to try and explain kind of the debate. We're saying, suppose you had a case where each person earned enough to support $1,000 a month child support obligation, right? That both parents had that amount. Well, the easy case would be if the children were with one parent 365 days and spent no time with the other parent. Well, then you'd use the full support obligation. There'd be no reason to adjust it at all. And so everyone could agree on that point. And then the other point everyone could agree on would be over here, which is if they both earn the same amount and they had equal time, 182.5 days, right? If you had equal time and equal income, there was no justification for a support order either way. So it would be set at 0. So you could agree on these 2 points. And then the issue was, well, how do you go from one point to another? And the first thing we thought was, well, you just draw a straight line. And we looked at that. And so here's about 90 days of parenting time, right? And the way it would work is every day that one parent doesn't have the child, they don't get support for that child. And every day that the other parent has the child, they get support. So if you get this, which is 25% of the time the children spend with the other parent, well, you only get support for 75% of the time, and you pay support for 25% of the time. So if you have equal incomes, that cuts support in half, 75 minus 25. Well, what does 90 days of parenting time look like? Well, there would be alternate weekends. That would be Christmas and Easter holidays, 3 weeks in the summer. And we looked at that and we said, that cuts support in half. That's a justification for cutting support in half in this kind of case. And nobody believed that. And part of it is all those costs don't transfer. You can't rent out the child's bedroom when they're gone for a weekend, right? You can't exchange your minivan for a compact car, right? Those costs remain with the person who has the children most of the time, and they don't all transfer to the other parent. I mean, you have food costs transfer, some other things, but most of the others don't. Clothing costs are usually with the parent who has the children the most. So we thought, well, all right, what do we do? So we decided on a curve, and that was this. And the way we designed the curve is what we call ratio of the squares. But basically,
that was before 2004, though, right?
This was back in the first schedule, I think, was in 1987. Okay. So that's when this started, was this. But even then, people looked at this curve and they said, we don't even think that should apply until someone has really substantial parenting time. So that was at least 35% of the time, which worked out to be 128 days. So you needed 128 days before you would get support calculated on this curve. The problem was that up until then, you got what was the normal visitation abatement. Anytime you had the kids, I think more than 8 days, support would be abated by 50%. So that's what this looked like. Go along like this until you got to 127 days. When you got to 128, your support did this. So oddly enough, and this was in effect for some time, there were a whole lot of disputes, and Kristin, you'll know about this, right? That people would be arguing about whether it was in the best interest for the children to have 127 days, or whether it was in the best interest of the children to have 128 days. And it occurred to people that maybe they weren't really arguing about parenting time. Maybe they weren't really arguing about what was in the best interest of the children. Maybe it was about support because there was this huge drop, right? From like 970 down to 570, something like that. Okay, you can understand why people would argue about that. So this started coming up more and more as people got more equalized parenting time. And I think finally, I'm trying to remember what I wrote it up, but I think it was actually in,
I know it's say 2012.
I think so. That we finally said, all right, we got to do something. We get enough complaints about this. So we redrew the curve. This pink line here is just a slightly different curve that was defined by ratio of the cubes.
But it got rid of the cliff effect, which is what the goal was.
And the benefit of it was only this, that it cut through the middle of this cliff. And it meant that we could now apply it to all cases. We said no more visitation abatements. Everyone just goes on this calculation. So the parenting time offset became universal and followed this curve. And that solved a lot of problems, but the problem that started to occur was this part, where for, let's say, the difference between 192 days and 182 days of parenting time would be, I'm sorry, 172 versus 182 would be about $200 in support, the difference between a zero order and a $200 per month order. Because at some point when you do this curve, you got to get down to the 0 point, where if you have equal incomes in equal time, it's got to be 0. So the more you kind of bow out here, the faster it's going to drop toward the end. And so, and I think this was in the 2017 maybe, where we drew a new curve that was just in between these two. And it's actually, instead of being ratio of the squares or ratio of the cubes, it's the ratio of the 2.5 power, which is something you can only do with a computer. It would be absolutely impossible to do any calculations now manually. So that's kind of where we are, and that's kind of the nature of what's going on with parenting time. And the dilemma of it is somehow or another you've got to take into account the parenting time, but it always has kind of unanticipated effects.
So that leads me to deviations and the fact that we calculate the child support based on the number of overnights. And before we dive, I have a bunch of questions, but I know Kent, you were sharing an anecdote. I believe Kristin, you have one as well, of when there was a situation where the parent who's really doing the bulk of the taking care of the children is actually not having overnights because of a third shift work schedule. And then maybe we can talk about like what that looked like, and then we could talk about how the deviation can fix that. Kristin, do you want to share the anecdote that you had from one of your cases?
Yeah, I was representing, it was actually the mother in that case, and she worked overnights. And the parties did get along pretty well in that case, which helped a great deal, but she took care of them during the day, but it really wasn't a fair situation to go strictly by overnights. And so they agreed basically to share 50-50, and that worked well for them, but clearly the overnights was not the way to go. In that.
Right. And so, and Kent, can you tell us how the deviation works when the overnights are not the driving force of who's taking care of the children, I guess?
So actually I'm citing the new one, but the deviation factor is a child in the custody. Oh, hang on a minute. Here we go. A parent provides a substantial amount of a child's daytime care and directly contributes toward a significantly greater share of the child's costs than those reflected by the overnights used to calculate the offset for parenting time. The case that I remember was a mother who worked night shift. And so every night she would feed the kids dinner, get them bathed, all that, and then take them over to dad's house, and he would put them to bed. And they would sleep overnight at dad's house. Mom would work all night. When she got back from her night shift, she would go pick the kids up at dad's in the morning, feed them breakfast, get them ready for school, get them off to school. As soon as they left for school, she'd sack out, sleep until then she'd go pick them up from school, get them home, get them settled, prepare dinner, cycle repeated, and then she would see them on the weekends, have them overnight on the weekends. But 5 days a week, every school night, they would be sleeping at dad's house. So he had the majority of overnights. But in that case, to say that she would have to pay him a lot of child support because he had all the overnights just didn't make sense. And so that's kind of a clear case where you would deviate from the formula.
So in Kristin's case, the parties were amicable, so they agreed to do that deviation. In a case where maybe they aren't agreeing with each other about the payment, is they just have to bring that to the court and let the court decide, request a deviation and let the court decide it?
Yeah, or I mean, usually it's front of the court, right? You're getting the initial recommendation and then maybe go to a referee hearing. But yeah, if they can't agree, just like anything, they get. And in a lot of these cases, you won't, I mean, your first recommendation from the front of the court might already have the deviation in it. In front of the court looking at it, so we're not going to recommend support based on him having 5/7 of the overnights. It just doesn't make sense.
So both Kent and Kristin do mediation, but because Kent's been like the leader with the child support in his background with the Friend of Court Bureau committee, I'm going to turn now to Kristin to talk a little bit about her experience. And of course, Kent, you can pipe in, but her experience as a mediator and how the overnights impact the ability of you to settle the case. Can you talk about like the dynamics of that, I guess?
Absolutely. The parties will often come into mediation either wanting more time or not wanting to give up any time that they've had. The reason may be due to child support based on overnights. Rarely will they admit that, certainly not in joint session. Sometimes in caucus they will. But one party feels like they've always taken care of the kids and that should just continue. Why should that change? I don't know, coming into it late, I don't know what conversations they've had, if any, how they've gone, So you're beginning the mediation with parents who may be hurt, angry, and just ready for a fight on that issue. So I try to remember that, my job as a mediator is not really to dwell on the reasons why. I do like to allow some venting. And I try to keep it under control. If it gets out of control, we take a break. But sometimes you just can't move forward until they get something off their chest. If you allow one party to vent, I always allow the other. And then I try to refocus them on the issue that we're there to discuss or issues. And in this case, parenting time. And I just try to get them back talking about that. I usually will start with the primary caregiver because they're usually the one that feels the most threatened. And so I want to find out, my first question to them is, what are your concerns? If you have concerns, what are they? And
I'm assuming this is in caucus so that the other parent's not there.
Not always. In fact, I like to start together. And if it's okay and safe to do that and you make that determination, before you start, and sometimes during. But if we're together, the other party can hear. If we're in caucus, that's fine too. It's just that my reaction might be a little bit different. But sometimes they'll say things like a significant other is posing a problem. Maybe the housing situation is posing a problem. The work schedule of the other party doesn't allow for certain things. Or I even had one where the transportation was an issue. There wasn't safe transportation, so the person couldn't pick up or take to school, things like that they would have had to do. Sometimes you get other types of concerns. And these might be things like, well, he or she has never done this, has never scheduled appointments, has never attended appointments, has never had to leave work to pick up a sick child from school, getting the children off to school, picking them up after school, even things like helping with homework. Maybe the other party just hasn't been as involved in those types of things. So if we're together, obviously the other party has heard all of these. If we're not and we're in caucus, I will talk to the non-primary caregiver. And I always start with those more serious concerns, because I've had cases where a significant other was an issue and it wasn't safe for the children. And actually, in that case, the parties agreed on that fact. And so we came up with some parameters that gave the primary caregiver some, assurance that the kids were going to be okay over there. And I think the fact the other party was going to work with her on that was helpful. I've had cases where the safe transportation was an issue, and one party agreed to do the driving while the other party, until they could get a vehicle that was safe. So sometimes you can work through some of those more serious issues, but I think they need to. And I talk to the non-primary caregiver, and I say, at some point you're going to have to answer these concerns. So let's do it now. It makes a whole lot more sense to do it now than when you're in court.
So I have a question, because a lot of the examples of concerns you raise they seem like legitimate, especially for a couple in transition from living in the same household to living in different households. There's a transition period that sometimes is a little bit of hard to adjust. What clues are there to you that child support's in the back, if they're not going to be upfront with you about that the child support's what is in the back of their mind versus legitimately being concerned about, the significant other, or, being in the car with somebody? Are there clues that you've seen? Like, I don't know if I'd call them telltale signs, but just something that would really help you understand that piece of the puzzle?
Well, yeah. So when I get a party that is fighting tooth and nail for more time with the kids, when they work 80 hours a week, I mean, they don't really get more time with the kids. To me, that's a sign. Like, okay, what do you really want here? But again, they don't really come out and say that. And, my job is not to get them to admit that they're doing this for the wrong reasons, right? And if they can step up and if they can do more, then, that's sort of the second part of this, where if we were in caucus and let's say the primary caregiver had those other concerns I talked about, I might take those on myself, and I would talk to the non-primary caregiver through reality testing, right? Well, what does it mean? I mean, what if a child gets sick? How are you going to work that into your schedule? Will your boss give you some flexibility? Can you rearrange your schedule so you can get out early or leave later and get to work later and maybe get the kids off to school, things like that. Talk about the reality of the situation, because, I mean, the reality is that if they want more time, they're going to have to accept the responsibility that comes along with that, and they're going to have to rise to those challenges. And if they can't do it, or they don't have the support system in place to make that happen, then it's not feasible. And they need to take another look at that and see what can work for them. And similarly, though, the primary caregiver needs to also give that other parent the opportunity to sort of prove themselves and show that maybe they can do more. They just have never had to.
So I don't know if we know the answer to this, and I'm putting this out there for both of you. Do we know why child support is based on overnights to begin with? I mean, I know we have a deviation maybe to help address it, but any thoughts about the fact that we're using overnights?
As opposed to what? I mean,
waking
right.
hours, I don't know.
that was the
exactly
issue, right?
As opposed to what?
That trying to figure out, you don't
it's easier,
want,
right?
You don't want the child support formula to be as complicated as the tax code. You want it to be something that's fairly easy for people to ascertain. And overnights are pretty cut and dried, right? It's hard to argue, well, he wasn't really there overnight. I mean, no, I mean, they were either there asleep or not. And so it's kind of an easy shorthand. And it really does usually encompass most of the care. If it doesn't, you can argue the deviation for some reason. But as a quick shorthand, something easy for parties to determine and easy to ascertain, overnights seem to be the most reasonable way to count that. Now, if you're working with an engineer, yeah, I mean, I remember one who was calculating the cost of peanut butter to 3 decimal places. But for most people, I think overnights is easier.
I think Kent, maybe it was you brought up an example of a court of appeals, a decision that misunderstood how the offset, like there's this disconnect between what you know from your work with the Friend of Court Bureau and the committee about how the parenting time calculations work versus maybe what maybe trial courts or even the Court of Appeals understands. They don't necessarily understand like the inner workings of how the calculations get to what they are.
Right. Well, the whole point of the parenting time offset is that each parent is actually paying support to the other, right? That it's not the immediate offset, but in each case, we're calculating here's father's obligation to mother, and here's mother's obligation to father, and we're offsetting them. And so in the Holmes case, which is one of these things everyone cites for, you can always agree to child support higher than the formula, that there's nothing wrong with that, and the court can enforce such an agreement. And it's like, oh yeah, I mean, that's in the best interest of the child, why not? But in fact, what you're saying is that in that case, mom support to dad could be less. Yes, thank you for the cite. Mom support to dad can be less than the formula, right? So to make dad pay more, you're actually saying mom's child support is less. And so you're skewing that. You can say, oh, so the kids are going to be better off while they're in mom's house. Because I think in that case, it wasn't completely 50-50, but it was substantial time in dad's house. They were going to be short-changed on resources at dad's house because a higher percentage were going to mom's house than the formula would say. And there was no recognition of that in the Court of Appeals decision. It was just kind of the old idea that, oh, one parent pays support to the other, and that's all there is. That hasn't been true, not even since I would say the very first formula, where we've been saying, no, each parent is paying support to the other person in their proper share. And so
it just means that if one parent only has to pay 10, the other one has to pay 500, it's really 490, right?
Right.
Going this way instead of back and forth, right?
Right.
Okay.
And in a case of substantial sharing, like there was in the Holmes case, the offset should have been substantial. Mom should have been paying a fair amount of support to dad. And the Court of Appeals essentially said, well, that support we don't care about. That support can be less than the formula, but to make dad support higher. And I think it's misunderstanding how much society has changed. I mean, I hate to say this, but I've been doing this stuff since 1980. And when I started doing support cases, the Court of Appeals frowned on the idea of any kind of support guideline. They were actually considered them to be a reversible error to use anything like that. And the proper way to determine child support back then was bags of receipts, right? To show what the needs of the child were. Somehow you could determine which children were needier than others, right? Because some kids got more support. Versus,
wait, so the referees would have to go through bags of receipts to try to.
Well, my guess is everyone used a guideline anyway, right? You just had to hide it. But it was, and so those were the old days, and it was always fathers. As a matter of fact, I remember there was a very well-known, well-respected family court judge in Connecticut who once said that any father who asked for custody should be sanctioned. And the reason was because the only reason he ever saw fathers asking for custody was to blackmail the mothers into reducing child support and property division, because they'd be so afraid of losing their kids that they would, and the fathers never really wanted custody. They wouldn't know what to do with it.
We're talking about the early 80s now?
Yes.
Yeah.
And prior. And when I read that, it was probably already 5 or 6 years old. But that was the nature of, I mean, our most common visitation complaint back in the 80s was, can't you make him visit? He's supposed to see the kids every other weekend and he never will, right? So it was just a different time. And so I think some of the judges are still thinking that, right? That fathers pay child support and that's all there is. And, you know, and especially back then, you would always get this issue of there would be expenses for the kids. And the kids would go, Dad, can you help us buy that? And you go, I'm paying your mom support. She's got all the money. She's supposed to buy all that stuff for you. And you still hear that, right? Whichever parent is paying support, I'm paying support. I don't know a dime other than that. Well, with the parenting time offset, you're not even paying support, you're getting support from the other party. So you can't use that excuse anymore. You can't say, hey, I'm the one who, when you balance all this, I end up paying a little bit more. So I don't have any obligation anymore. If you're getting a parenting time offset, you better be picking up some of those kids' other expenses too, right? You owe a portion of their clothing. You owe a portion of their school fees. You owe a portion of everything else because you're getting the benefit of that parenting time offset.
The Q&A, right? I think I've been able to address everything so far. Kristin, do you have any more examples to share with us of, you know, the parenting time and child support, I guess, tension or connection?
I mean, not really. I did have one nice case where the parties fought like cats and dogs over property. And when in the initial consult, and I was asking her about, you know, well, where are you guys on the children and all that? Oh, he's a great father. We're going to share 50-50, all this. And it was just kind of amazing. I never had a case like that up until then. So that's kind of the opposite of what we're talking about, but that did come to mind.
Hey, it's good when parents can get along and not have to fight all the time. So we have another question from the audience, from a former referee from Oakland County, now another mediator. You guys are popular. Is it clear when the other party, the paying party, can deduct the net actual cost of healthcare coverage? In other words, why should there be a difference between mandatory or voluntary healthcare coverage under the Michigan Child Support Formula 2.07? It seems to me that the paying party should have the opportunity to obtain health insurance for themselves and have the right to use it as an allowable deduction for purposes of calculating their support obligation.
Not sure I fully understand your question, I'll have to admit.
Let me read it again.
So this is
Why should there be
207, what section does she cite?
207F. It's actually he because somebody's using somebody else's account, but they're both former referees, so I would still write 207F. Why should there be a difference between mandatory or voluntary health care coverage? The party paying should have the opportunity to obtain health insurance for themselves and also have the right to use it as an allowable deduction for the purpose of calculating their child support obligation. So if they pay more, right, for the health care, why isn't, I think the question is, why isn't it used as an offset to reduce their child support obligation? I hope I'm saying that right.
Yeah, I think it's in line with all of the basically mandatory deductions from income are generally excluded, like union dues, things like that. If it's mandatory, it's like they've got to pay it. There's not. It's the same thing when union dues became voluntary. Then at that time, they weren't deductible from income because you didn't have to do it. It was a choice. But things like taxes and mandatory deductions were excluded.
And I got a private message. I won't call it any names, but there's a little bit of an explanation here. 207F, the section that we're just referencing, is a self-coverage deduction, a deduction from income, whereas 305 is a premium adjustment, and that does consider both parents if both are providing insurance. Does that make sense to you, Kent?
Right. Well, and the other thing with premiums now, I mean, there used to be this big argument about who had to cover the kids on insurance. And now it really should be something that both parties are trying to figure out the most cost effective, because they're prorating it anyway.
Mhm.
So if you're earning 40% of the income, if you get a better deal on the insurance, then you should pay it, because you're only paying 40% of it anyway. If it costs the other party more, why pay 40% of more when you can pay 40% of less, right? You should always be looking for the most effective one, and you're still paying the same proportion.
Now, somebody asked for a quick recap of the changes, and my response was that we're going to be providing those on paper. But
Yeah.
I didn't know if you had any other comments about the changes or anything else. We're doing good on time, but we could wrap up a couple minutes early too. Nobody's going to be complaining about that, I'm sure.
Yeah. When Kristin was talking about the problem of discerning in mediation, whether someone's really arguing about child support or if they really want more time with their kids, I had a fellow mediator who would, when people, especially guys arguing, I'm an equal parent, I have equal time. And he would say, yeah, and I think we should just equalize incomes in this case. That way you both have the kids equal time and they have equal. And there were cases where the guy said, fine, that's fine. I just want to spend more time with my kids. And of course, the other party would look at him and go, really? I mean, you don't care about the money? They go, no. He said, oh, and the case would settle immediately, right? But I hate to say, but his report was that didn't happen very often. That
Well,
as
and
soon as he would suggest,
I've also seen, yeah.
as soon as he would suggest, all right, you're right, 50-50, let's just split incomes. Most guys would go, that would be ridiculous. That would be more money. My point is getting less money. I mean, more time with my kids. But yeah. And you know, this whole thing about child support, I keep saying child support is not a meal ticket, right? That trying to make a living on child support just doesn't work. If I was advising people financially, I would say give custody to the other party, pay child support. You're going to be a lot better off financially, right? Emotionally, no, your kids will be a mess. But hey, in terms of your financial, and I worked with a woman whose husband complained nonstop about his child support. He was just, oh, it's terrible. And she said, you know what? The girls miss you. Why don't you take custody and I will pay you child support, right? They miss you. They'd love to spend more time with you. He said, oh, yeah, you'll pay me child support. Sure. So he took custody. She paid child support. She said, for girls, we're thrilled. I mean, their dad was not nearly the disciplinarian she was. They love spending time with them. And 6 months later, he begged her to take the kids back and never complained about child support again. Because it was like, oh, this is hard, right? And I don't have time to do anything else. I don't even have time to find the new wife who would do all the childcare for me, right? Because I've got 2 girls that are taking up all my time. And I think that, yeah, this idea that, I mean, it's kind of that thing with the people who want to impute income to someone and not childcare. It's like, no. I mean, the person who's being a stay-at-home parent to take care of the kids, it's a financial sacrifice. They'd be far better off going to work, incurring childcare that would be split between the parties, and they'd be far better off financially. And they're really providing a financial benefit to the other party by not incurring the childcare costs. But yeah, people never realize that.
And you know, I think too, one thing is forgotten, that child support does not cover everything. And the parent who does take, you know, more of the parenting time is their responsibility. There's always incidentals and things that you don't think of, and costs pop up, and those are not factored in. And so you got to kind of consider that too.
Yeah, that's a good point. There's always, it seems like, well, one, there's running around, bringing the kids to all the different places they need to be, right? That takes up not only time, but gas. But like, there's always something at school that the kid needs $5 or $10 or, you know, it's not something that's like set ahead in advance that you're going to have already arranged to divide up. Somebody else in the Q&A, Kent, gave almost the exact same example from their own case docket that happened to them with one of their clients, that the one parent said, here, you take the kids, I'll pay support. And that didn't last very long. But I did have one last question. And I wonder if, Kristin, if you've seen this, where I've had clients who wanted to change domicile and maybe move out of state. And they so wanted to move out of state for whatever their reasons were, that they've said, I'm willing to waive support, which I'm not even like sure it's possible, but like, I'm saying, like, they weren't trying to get more support. They were even willing, even though they became the primary caretaker because of the out of state situation, except for like the summers and, the breaks that the child was able to travel back to Michigan. Have you ever had a situation like that where one party's like just even putting the financial obligation onto them, and how has that worked out for you?
Yeah, I did. I had a couple cases like that, and one, the move was granted, and the other one, it wasn't. I thought the referee actually did a pretty good job of analyzing both cases and really trying to equal out the parenting time as much as possible. One of the cases was the one, I think, if I remember correctly, the wife wanted to move to Ohio, and I represent the husband, and they granted that move. And then, but gave him, and I tried to impress this upon him, they gave him significant parenting time. I mean, he had, sometimes what I focus on in mediation and when I was practicing is quality over quantity. So maybe you don't get the day-to-day, but if you're getting significant time in the summer and all the long weekends, because they could make long weekends work, then
With Ohio, you could, right?
Then maybe that's worth it. And the other one was more like a 10-hour drive, and I can't remember exactly where it was. It was west somewhere, and they granted, and I represent the mother who wanted to move, and they granted that because the child, even at a very young age, her family was out there and they had a family business, and her job opportunity was going to be just much superior to what she was able to get here, and the family really needed the money. So they granted that as well. But again, they tried to equal out the parenting time as much as they could, and the child was used to that drive and tolerated it very well. So, in that case, they granted it again. Yeah.
Well, I don't see any other questions, so I want to thank you both again, Kent and Kristin, for your time today. Really appreciate it. And I just sitting here, I've gotten ideas for more webinars for later on, that kind of are offshoots of our little conversation today. But thanks again, and remind everybody that you will get the recording, and also we'll be sending out the takeaways, like I said, hopefully tomorrow or early next week, so that you can get to those links and that history that Kent so graciously prepared for us. So again, thank you, everybody.
Thank you.
Thanks.